job in finding different issues in a case, and you say that you have a strategy or a tactic how you identify those issues in a case. Is that correct?
Yes.
Okay. And is it your practice to look at the motion for new trial order that a court issues out? Like if they issue out a motion for new trial order, is it your normal practice to look at that order?
Yes.
Okay, and what would be the reason for you to look at that order?
Because that's what we're appealing. And sometimes, well, you have to figure out whether you won or lost, and if it was partial, which parts you won, which parts you lost. In your case, we won part of it. We got rid of count 12 completely, and we lost on the other count that you're serving your sentence on. The other reasons to look at it is, a lot of times the DAs draw these and they're still controlled for the state. The appellate courts don't really look at it that much because they have the right to make up their own mind. But occasionally there are findings of fact in that order that could be the subject of the appeal.
Okay. And in that order, do you have a way of pulling up that order?
Got it right in front of me. What do you need?
Okay, on page 1 of that order, can you read the bottom paragraph for me?
It's partial. You want the last full paragraph or at some point?
The most interesting part of that would be the very first sentence of that order, but if you could read that partial that you have.
At some point, off the record and outside the presence of defendant, the court asked the bailiff to instruct the jury to fill out a verdict form to indicate its verdict as to any count on which it had arrived at a unanimous decision.
Okay, can you read that first part again for me, just so the record is clear what the court admitted to saying?
Oh.
Did you? I couldn't hear, Your Honor. That's why I'm asking him to restate what the order says in the beginning.
And then we did tend to tender a copy of that order, so.
All right, if you can restate that for me,
At some point, off the record and outside the presence of defendant, is that the part you wanted?
Yes, if you can continue reading.
Outside the presence of the defendant, the court asked the bailiff to instruct the jury to fill out a verdict form to indicate its verdict as to any count on which it had arrived at a unanimous decision.
Okay. Now, looking at that mention there, does that sound administrative, or does that sound like a substantive instruction?
Administrative. Courts do that all the time. It's not a thing.
Okay, courts do that all the time. Okay. Are you familiar with the case Lindsay versus State? Are you familiar with that?
No.
You're not familiar with that case?
No.
Okay, so is it not a violation to give such an administrative instruction on the record? And
I've never seen it done on the record at all, ever.
So you never seen a judge on the record instruct a bailiff to go talk to a jury off the record?
Did you not hear me?
No, sir, I didn't.
I said no.
Okay. So it is your position that is okay for a judge to delegate a power that the judge is supposed to do to a bailiff. That is your position.
The judge is not supposed to go in the jury room, so no, that's not a delegation.
Okay, so can a judge...
Okay, the bailiff that's what the bailiff is hired for. Okay,
so the bailiff is hired to tell a jury to put in the verdict that you have reached and the verdict that you don't have, leave them blank. That's the bailiff's job.
Among other things.
So what is comfort and convenience exactly?
I don't know. I know what it means to me.
What does it mean to you?
Watching TV and eating chips. What do you mean with comfort and convenience?
So specifically, the Georgia Supreme Court stated that any type of conversation, communication with the jury done by the bailiff is strictly and is prohibited to just comfort and convenience. If it's not comfort and convenience, there is no form of communication that is permitted by the Georgia Supreme Court. So judging by this order that the court has issued out, stating that at some point off the record and outside the presence of the defendant, the court asked a bailiff to fill out a verdict form. That's dealing with the verdict, is that not correct?
Yes, that's correct.
Okay, so when you're dealing with a verdict, who has the duty and the responsibility to instruct on how to fill out a verdict form? Whose duty is that? Is it the bailiff's duty or is it the judge's duty?
It's often part of the instructions to the jury, and the verdict form usually speaks for itself.
Okay,
It's just a question to make back and ask the judge.
I'm going to restate the question again because whose duty is it to instruct the jury on how to fill out a verdict form? Whose duty is that? Is it the judge's duty or is it the bailiff's duty?
It's not required by law, but it's normally part of the judge's instructions to the jury.
And why is that normally part of the judge's duty to instruct the jury on how to fill out a verdict form?
Not what I'm saying.
Maybe ask some questions that would show how representation was effective in the
Okay. So, in your brief, you stated, for some reason you quoted that specific statement that the judge gave an ex parte communication in way of accepting a partial verdict. When you looked at the motion for new trial order, you didn't see that is a violation of your client's right to be present by having a bailiff go back to the jury and instruct the jury, especially a hung jury.
That's correct. That's not an issue. I didn't raise it on purpose. And if I was wrong not to raise it, you got to say. Okay, so how would you know the specific words of the bailiff that he gave to the jury? How would you know that? I don't.
Why wouldn't you know the specific words that was used?
Because I wasn't there.
You wasn't there? And let's say, for example, you're an appellate attorney, so you come after the fact.
Yep.
If the trial attorney wasn't there to know the specific words that the bailiff used, how could you know if he coerced the jury to a guilty verdict? How would you know if it's done off the record?
We don't.
Okay. And it's easy to say that it's very unfair to a client to have a bailiff go and instruct the jury off the record since you can't say exactly what was said to that jury. That is very unfair. Is that correct?
No.
It's not?
The judge sending the bailiff to tell the jury something, or ask them how they're doing, or ask them are they close to a verdict, or, that happens all the time, and it's not unfair. It's just administrative stuff. So the bailiff was just repeating what the judge said.
That's not the question. That's not the question. What I'm asking is, if the instruction itself, if you don't know the exact words that was used by the bailiff, regardless if it's administrative, let's say, for example, if you send a bailiff to say, hey, stop a verdict, right? And you don't know exactly what was said, how can you object to the words of that bailiff if you do not know what was said?
Okay, I'm failing to see how this bears on the appeal. If the trial lawyer wants to know what was said to a jury, he can interview jurors and after the fact and things like that. I didn't raise this issue because I thought it was a non-issue, and if I'm wrong, I'm wrong.
Okay, and it's clear, and the Court of Appeals agree with this in Lindsay versus State, that even administrative instructions given off the record outside of the presence of the defendant to the jury is presumed prejudice.
Mr. Allen, you have got to ask him questions. You are testifying.
Yes, ma'am. Now, you're saying that the issue that the attorney was insufficient for failing to file a suppression, motion to suppress warrant, you believe that was stronger than a violation of the right to be present?
In your case, yes.
Okay, so from your testimony, you're saying that the argument of not filing a motion to suppress was stronger than a client's right to be present being violated. You feel like that was stronger than arguing, a client's rights being violated?
Yes.
Okay.
In your case. Normally, If there was a legit violation of the right to be present, that would be the number one issue.
And what would make it a legit claim?
If the trial attorney told me that the judge did something without the defendant being there, or it was clear on the record that some argument went on, and then the record says, oh, then the defendant walks in. If it's clear to me from the record and the evidence that the defendant was not there during a substantive part of the trial, a critical phase, as they say, like, jury selection or even sentencing or whatever.
And if
A client does not skip town, which has happened to me, that's a great issue because it means reversal. But I did not see that in your case. And if I'm wrong, I'm wrong.
Okay, now, jury deliberation, that is a critical phase, is that correct?
The defendant has no right to be part of jury deliberation.
No. I said jury deliberation, is that a critical phase?
Not in this context.
So when a jury is deliberating, right, or before, when you're instructing the jury, that's not a critical phase?
Those are two different things.
Okay, so
Jury instructions are a critical phase, and the defendant has the right to be there for that. But normally, once the case goes back with the jury and they're deliberating, the defendant can go back to the prison, he can go home, whatever.
No, that's not what I'm asking. That's clear.
I'll use the right terms.
That's clear. So, the defendant doesn't have a right to go back to the jury deliberating room. That's understood. But if the judge was to re-instruct the jury or give a supplemental instruction, there is an absolute right to be present for the defendant since the jury is in deliberation. Is that correct?
The jury would be in the box at that time, they would not be in deliberation, and yes, you're correct, the defendant would have the right to be there, and it's normally in the transcript.
And what is that right? What right is that to be?
Right to be present during your trial, it's due process.
Okay, and that's what I'm asking. When a jury is deliberating, and let's say, for example, they send out a note saying that they are undecided, the judge brings them back to the courtroom. If the judge decides to re-instruct them, is that a critical stage?
Yes.
Okay. Thank you. Now, the question is, since that is a critical stage, is it not a violation of the right to be present for the judge to re-instruct them on how to stop deliberation?
I don't understand the question and how it relates to ineffective assistance.
It relates to ineffective assistance because you did not claim that, and it's clear that the court admitted that they instructed a bailiff to instruct the jury how to stop deliberation.
Well, from my understanding of the record, the bailiff did not give the jury any instructions on the law or how to decide the case.
So how do you know that if it was done off the record?
I reviewed everything about that issue and chose not to raise it in your case because it was too weak or I did not believe it was meritorious.
Okay, so you said you reviewed everything on the record. So did you review the part that the court said that it was done off the record?
Yes.
Can you move on to this? I don't know what else we can say on this issue.
Yes,
He
ma'am.
said that he considered it, he didn't think it was one of your best grounds, and if he didn't raise it and should have, he pretty much said that, but that's on him.
Yes, ma'am.
But, I'll give you a couple more questions on this, but we need to move on to something else.
Yes, ma'am.
Okay.
All right, so again, you didn't raise it, it was a right to be present, okay. All right, so as far as the 17-8-3, the no pros, are you familiar with that statute?
Somewhat.
And what is it required in order to be entered?
Okay, I think you're asking about the procedure for entering an all-pros. Once the trial is started, the defendant has to consent to it. That's what you're getting at, I think, right?
I just asked you, what is it required in order to be entered?
Okay, I don't know.
You don't know?
That's correct.
Okay, all right, so I'm not going to ask you to do any legal research right now. So if the statute states that it requires the defendant's consent, and you have, during the motion for new trial, you have a trial attorney, and basically testifying that he caught the prosecutor leaving the courtroom and asked him if he intends to retry then, and that he did not disclose that to the defendant, how would the defendant know that a no process was going to be entered if it was never discussed with him?
I don't know.
So that would be a violation of your client, is that correct? If the statute states that it requires consent from the defendant, and the conversation with the trial attorney and the prosecutor happened leaving the courtroom, that would be a violation of the defendant, wouldn't it not be?
I don't know.
Okay. And this case did end in a no process?
Yeah, you know, we litigated that in the Court of Appeals, and you know the result. I tried my best.
Okay, and I'm glad you stated that. In the Court of Appeals, you put on your brief, while it is likely that the defense would have agreed to the no process. Where did you get that? Where did you get that information from?
Common sense. Everybody I've ever defended would never objected to a null process because that means their case is going away. I mean, that's obvious, isn't it?
So you use your common sense over the defendant's right to a trial by jury.
I don't know what that means.
The defendant has the right to a trial by jury. Is that correct?
Yeah, but you know, if you're going to get your cases, your charges dismissed, you generally don't want a trial.
Okay, so you referenced a no process as a dismissal. Is it a dismissal with prejudice, or is it just a dismissal?
It's not with prejudice, but for all intents and purposes, the state is not going to retry you, especially since double jeopardy probably forbids a retrial. But
why would
from experience in the courts, it's a great thing to get.
Okay,
State gives up.
Okay, and why would double jeopardy apply here?
It wouldn't. I was just, explaining the concept.
Okay, you explained the concept. What was the reason for you explaining that concept of double jeopardy?
Because an all process and a mistrial and a hung jury, all of these things involve double jeopardy. A person can't be tried twice offense. The reason the state can't retry some things is that they've already been tried. In your case, it was doubtful. With most of the aggravated assault and gun charges would have merged into the armed robbery anyway, and they had a verdict on the armed robbery. So that means they probably couldn't have dropped the ag assault in the future because double jeopardy. It's the same fact, the same incident with the same victim. So they didn't lose anything by not crossing those, since they knew there was a verdict on robbery. Okay.
And do you believe that the supplemental statement done by the bailiff could have been the determining factor that stopped the actual deadlock? Because the jury sent out a note stating that they were deadlocked in this case. Is it possible that the instruction could have been the determining factor of that deadlock? Because soon after the instruction was given, there was a verdict, and it happened directly after the instruction. But before the instruction, the jury was deadlocked. So after that instruction, do you believe that basically determined the verdict? It helped the verdict because the jury was deadlocked, was they not?
I'm not sure what that has to do with my job and what I did.
So your job is to identify all issues that. Okay, so Mr. Clark, is it your job to identify any errors that would reverse a conviction?
Yes.
Is it your job to either get a full exoneration or at least a motion, or at least a new trial?
Full exoneration, yes. I try my best to either get a acquittal, which is possible, a new trial, which is possible, a remand for some redetermination of facts, or a modification of the sentence. That's all you can get on appeal.
Yes, so your job is to either get a new trial, a full exoneration, or some sort of relief for your client. Is that correct?
Yeah.
Okay. And a violation of the right to be present, what would that do in the appeal? Is that a presumed prejudice, or is that something that you have to prove?
It's presumed prejudice, but I don't think it happened in your case. I could be wrong.
Okay, you could be wrong. You could be wrong. All right, so
absolutely.
Now,
happens every day.
So in this case, in this specific case, when you have testimony that you extracted from the trial attorney that stated that he had a discussion with the prosecutor leaving the courtroom, and that he did not disclose that to your client, or to the client, that is a substantive decision to make, is that correct? To have the state dismiss the count and not inform the client of that dismissal, especially a no cause that requires consent from the defendant?
If it happened the way you just said, it might have been wrong, but it didn't harm your chances at trial, which is the second prong of ineffective assistance of counsel. So even if I agreed with you, which I'm not sure I do, that's not going to rise to the level of ineffective assistance on appeal.
Okay, you said if it happened. You said if the prosecutor and attorney discussed no cause and didn't inform the client of that decision, that would be when that happens. Is that correct?
I don't understand your question.
So you stated if that happened. During the motion for new trial, did you not ask the attorney about how the charges was handled, the count 7 through 10? Did you not ask him how those counts was handled?
I recall asking about that, not the exact response or anything.
Okay. Now, his response was that he called the prosecutor, and you asked him this twice, and then you have to clarify it. You asked him, when did the conversation happen? And he testified that it happened leaving the courtroom, and you specifically asked him if he's discussed that with the client, and he answered in the negative and said no. Dismissing a count with no cause that requires the defendant's consent, it would require, in order to say consent, that means the client has to be fully informed of the entry. Is that correct?
I remember raising this issue on appeal and losing, and whatever the Court of Appeals said is the right answer. I asked him about it, and I thought it was important, and I was exploring a new issue that really was kind of first impression, because it's really rare for a judge to accept a partial verdict without declaring a mistrial, and this judge didn't do that. So I was poking around for any evidence I could get to try to help you, and part of it involved the lawyer possibly agreeing to a null pros without you, or agreeing to something without your consent, but it was a dead end.
Okay.
And I raised the issue as best I could. There wasn't a lot of law in support because it hardly ever happens. I've never seen it happen in 30 years of trying cases, where a judge doesn't wrap it up by declaring a mistrial and accepting the partial verdict, but this judge did. But it might have been because everybody knew the null process were coming later. I wasn't there, so that wouldn't be unusual, and I don't think it's a violation of anybody's rights.
Okay, and this is where the ineffectiveness comes. You stated that you raised the issue to Court of Appeals. Is that correct?
Yeah.
Okay. Now, when you raised the issue, the Court of Appeals specifically quoted your statement that you put in the brief that while it is likely that the defense would not have objected, they used that from your brief.
Yes, 100% true.
One second. Where did you get the information that the no pros would have been consented to? Where did you extract that information from? Did you consult with the client?
I didn't ask you. I made it up. I didn't ask you. I based it on my experience as a lawyer.
Okay. So
I didn't say that you agreed to it. That would have been a lie.
Okay, but since the Court of Appeals used that,
it's likely.
So since the Court of Appeals used that statement to imply consent to the null pros, that harms your client. Is that correct?
I'm not sure your assumption is correct, and I'm not sure it harmed you.
So,
getting your case dismissed is usually good for you, so I don't agree with the premise.
So again, the Court of Appeals used your statement while it is likely that the defendant would have accepted, and it opened the door to harmless error. Your statement that while it is likely that the defendant would have accepted the null pros opened the door to harmless error. Okay. Now, also the Court of Appeals stated that you failed to cite any of the page numbers that supported that argument. Is that not a deficiency?
I don't know. It's not for me to say. I agree with you that Court of Appeals, is that what it said?
The Court of Appeals specifically stated that you did not put any page number to basically to sustain your enumerated errors, or to basically uphold your enumerated errors.
What's the question?
The question is, was it a strategy of yours not to actually put the page numbers that supported your claims?
No.
And what would be the reason that you didn't put the page numbers?
Oversight.
Oversight. Can you explain that? Elaborate a little bit more what that means, oversight?
No.
Okay. Now, when it comes to, do you remember emailing an email by the title roadtosuccesstv@gmail.com?
No.
You don't remember emailing? You don't remember sending emails to that?
I remember I got a few and responded to a few. When I found out that it was not you, I stopped communicating with that entity. I don't know who it is.
So your testimony is you was responding to that email at one point?
A couple of them, yeah.
Okay. Now, do you remember being informed that the no proc was done without consent and done outside the presence of the defendant? Do you remember that specific email?
No.
Okay, refresh your recollection if your response to that email was read on the record?
Probably.
Okay,
And Judge, I would ask that it's going to be read, that it only serves the purpose for refreshing recollection. I understand we have some difficulty with Zoom showing it in person.
Absolutely. Do you want to see them first before?
The email.
The relevance is that he was informed of the issues of the no proc being done without consent, and also the ex parte communication of my jury. He was informed of that, and he completely winnowed those arguments out and chose to go with ineffective assistance of trial counsel only for failing to submit suppression motion to suppress, which is significantly weaker argument to a right to be present, and significantly weaker than the argument of handling charges without the client's consent. Those arguments are significantly weaker.
He's already testified to that.
No, he didn't.
I'll let you see. I'll let Ms. Marley see what you got on.
So these are the emails directly to him, and again, what he says, and these are Gmail, and he has his stamp for self-authentication, and specifically is where he was told to file a supplemental brief before the Court of Appeals made their decision, after he noticed that he had injected those statements into it.
So, Judge, Mr. Clark can testify as to anything he responds to these emails, however, I object to the content of the email sent to Mr. Clark as hearsay. Because it sounds like it's not. Judge, if you look at these statements, the person made these statements, it's not Clark to testify today. Okay.
No, and I would like to state for the record, I was the party who created these emails. I sent the email to him, and he responded to me.
You can ask him if he was aware that that was usually who he was communicating with, but we'll see. I'll reserve the legal on that.
Mr. Clark, and I'm glad you did bring that up. Is it not a violation of your ethical duties to disclose information to a party that you are not familiar with who they are?
I don't understand the question. Can you rephrase it?
This question is irrelevant. It was not raised in any of the grounds of any of the amended petitions.
It's a credibility issue.
It's
a credibility
You need to
issue.
tailor your question to the grounds raised in your petition, okay?
The issue is I'm attacking him for ineffectiveness,
I understand.
and that goes strictly to credibility. He's not reliable. So it's actually admissible by party opponent, but she's objecting, stating that it's irrelevant, and it goes directly to being ineffective.
What did I do wrong?
And I respond, Judge, first, it's not in addition by party opponent. Like I stated earlier, the party opponent in this case is the warden. Mr. Clark is Mr. Elam's witness. Also, the state of the ineffective the council is not a general thing. It has to be about specific issues. Mr. Elam has already stated which specific issues he wanted to raise, and in many amended petitions that he filed with this court, whether or not Mr. Clark was ineffective for disclosing information on the email chain was not raised. The standard is if there was a specific deficiency that has specific purposes. So this is an irrelevant question.
I agree.
I can understand what she's saying. Now, Mr. Clark, you were informed that the no proc was done without consent on the email. You not remember being?
I agree.
Okay, so you were.
I agree.
Okay, so you were informed that it was done without consent, and you were informed that.
I knew all about it.
Okay, and you were informed that the client would have not consented. Is that correct?
No. That was irrelevant.
That's irrelevant? Why is that?
Because I think so, yeah. But I considered it irrelevant.
Okay, you find it irrelevant that the court violated the right to your child or jury.
That's not true. That's not what I said.
I mean, dismissing a charge after the charge has been tried by a jury, and there's no decision on it, that jeopardy has attached. So in order to get a no process, does it not require your client's consent?
No.
So basically you're changing the law, you're changing the statute. That's basically what you're saying.
What? No.
Okay, so specifically 17.8-3 states that after the case has been submitted to a jury, it requires the defendant's consent. Does it state?
Okay, yeah. Sorry, I misspoke.
Okay, so does it state that it requires the attorney's consent, or does it state? Does 17.8-3 state that it requires the attorney's consent or the defendant's consent? Which consent does it require?
You've got it in front of you. I don't know. I think that the attorney can speak to the client in that regard. Maybe not. It did provision. So your understanding of and litigated in the Court of Appeals.
Right. So your understanding of no process.
That can't be.
I'm sorry. I don't mean to cut you off.
No, I read the statute. I understand the statute.
Okay, so you said you understand the statute, and your understanding, which you just testified to, that you can apply consent.
I don't know the answer to that. I'm not sure that's what I said.
Okay, so with the statement, while it is likely that the defense would have not objected, is that not an implication that it would have been accepted?
I don't think so, but, you could read it that way.
Okay, so, and if you could read it that way, that gives the appellate court an option to overlook the violation. Is that not correct?
That's not correct.
Okay, so you just said that it can be looked at that way. Since that is an option that it could be looked at that way, does that not give the opportunity to overlook a violation?
No, not by itself, because a harmless error analysis is far more complicated than whether someone agreed to an all-cross or not.
Correct. And you just stated exactly what the court has stated, that it was harmless error due to your implied statement that it would have been accepted. The court specifically relied on your statement that while it is likely, and Your Honor, is it possible that I can have the state provide a copy of the Court of Appeals order on that specific page so I can quote for the record exactly what the Court of Appeals stated? Because they specifically used his statement to imply consent, where the statute clearly states that it requires the defendant's consent, and they used his consent for the no process.
I got it. I understand what you're saying.
Okay. I just wanted to make
A lot of
sure.
questions about this.
Yes, ma'am. I just wanted to make sure that it was clear that they found some error due to his wording. And specifically on the email, way before the brief was even filed, he was told that the no process was not agreed to, would have not been agreed to, and he still put that in his, and that was a misrepresentation of, and also a conflict, because you're saying this, but your client is saying a whole nother thing. So, Mr. Clark, also on the email or in a couple of written forms, there was a request for you to supplement your brief due to those statements. Is that correct?
I don't remember.
You don't remember? So you don't remember being asked to supplement your brief?
Assuming you did, I chose not to.
And what was the reason of not supplementing your brief?
I thought it was good enough.
You thought it was good enough? Okay. And
Yep.
are you familiar that your client tried to file some pro se motions with the Court of Appeals?
I don't remember. That wouldn't surprise me.
That wouldn't surprise you? Your Honor, may I approach, please? These are the Court of Appeals returning the motions, trying to supplement these errors, and them rejecting due to hybrid representation. In 2023, they specifically stated that no Constitution bars pro se litigants from litigant that's represented by counsel to submit. It's a discretionary thing, and if it's to protect the right, the court, has leave to hear that motion. And specifically, the errors that I asked him to file was errors of my absolute right to be present and my absolute right of trial by jury. I asked him to supplement his brief to show that, because the court did admit to instructing my jury outside of my presence after an Appellate charge during deliberation, which is a critical stage. That is a right to be present violation. I asked him to submit that on his brief, and he went up that out, saying that his argument of the suppression was stronger than the right to be present. And this was me trying to preserve that claim so it wouldn't have been procedurally defaulted. The only reason why the claim was not given to the court to rule on is because his ineffectiveness. He chose to not claim it.
What's the response from the agency office?
If they're being offered to show that the Court of Appeals did not allow him to do hybrid representation, that is not a ground that has been raised.
It is.
At the beginning of the hearing, we went through all the grounds that were raised, and we asked if there was anyone to add, and there was nothing added to what was read into the record at the beginning of this hearing. If it's to show that Mr. Elam wanted these issues raised, I think that's abundantly clear from the hearing that we've had today. If they're court remitters, then I don't have an objection to them.
Your Honor, the actual ground that this is raised on was actually filed on February 20th, which was a couple of days ago. It was filed directly after her answer. And that is another issue that I would like the court to address too, the lateness of her answer. I haven't received her answer yet, but I'm very familiar that she filed one on February 19th, which was Friday, and I've yet to receive that. I've yet to be given an opportunity to traverse that. So if she's saying anything in that aspect, I would ask the court to find them in contempt for filing a late answer and not giving me the opportunity to answer to that.
We're going to make the best use of Mr. Clark's time right now.
Yes, ma'am.
If you have some questions for him, ask your questions.
Yes,
If not, I'm
ma'am. So
going to
the question is, I wanted to present this so I can ask the question as far as the supplemental, but before I submitted it in, I wanted to make sure she was okay with it.
You can ask him whether or not he solved all of this, but whether or not she sent all that to the Court of Appeals is not relevant to what he did. I mean, it's not relevant to his representation.
Well, it's relevant because now the state is trying to use that. The state is trying to use his ineffectiveness to procedurally bar me from my right, my constitutional right to be present. procedurally barred me from my absolute right to a trial by jury. And it's completely harmful for me because I tried to file it in a court of appeals. The only reason why the court of appeals did not rule on this, which is a presumed prejudice, it's not something that I have to prove. The fact that it happened and the court admitted to it, it's a presumption. You chose to file ineffective assistance of counsel on a suppression issue and skip over the court.
We're going to make good use of his time. Ask him questions if you have any more questions.
Yes, ma'am. So I have a question. It was a strategy of you to not raise the issue, even if you felt like it wasn't strong. It was a strategy of yours not to argue the fact that your client was completely left out during the supplemental instruction to a hung jury.
I disagree that there was a supplemental instruction to the hung jury. I willfully decided not to raise anything more than I did with respect to what the bailiff told the jury because I thought it was in your best interest.
Okay. So did the court find a manifest necessity to stop this trial?
No.
They didn't?
I don't think so. I don't think that phrase was used in the transcript.
So you don't think the phrase was used, but do you believe that the trial court found an absolute manifest necessity to stop this trial?
I don't know what you mean.
From the record, you are the reviewing attorney that reviewed the record and filed a brief in this case. After you reviewed the record, do you, from your experience, do you see in the record, or remember from the record, if the court absolutely found a manifest necessity to stop the trial? Do you remember the court finding that manifest necessity?
No.
Okay. So, since the court did not find that manifest necessity, instructing the jury to put in what they have and leave the rest blank, is that not a supplemental instruction to an Allen charge? Does that not contradict an Allen charge? An Allen charge asks them to keep going and to...
I know what it is.
We know what the Allen charge is.
Okay, so the Allen charge was given.
Yep.
And you stated that no manifest necessity was found to stop the trial. What do you feel the reason for the judge telling the bailiff to tell the jury to fill in what you have, leave the rest blank, let me get that verdict? What was the reason for that?
I don't know. I don't want to speculate.
I'm sorry.
I don't know. I don't want to
As
speculate.
to what the court's motive was.
Jason sustained.
Okay. What was your reason to allow the trial attorney ineffectiveness to not be claimed? Since you're claiming the trial counsel was ineffective, why not claim as an enumerated error, a possibility, even though it might not have been shown, it's still a possibility that it was a violation of the right to be present. Why not include that as an enumerated error?
As I explained at the beginning of my testimony, I made choices as to the strongest and weakest issues and chose not to raise that.
Okay, and in your response, you stated that these errors were non-frivolous. Is that correct?
I don't know what you're talking about.
And your response, in your response to the bar on these same issues, you responded that you chose not to submit these errors even though they were non-frivolous. You stated that to the bar. Do you not remember that?
No.
Okay, specifically on counts 7 through 10, you stated, as to the remaining complaints, I declined to file a supplemental brief as there is no right to file a supplemental brief in the Court of Appeals, and I decided there were not grounds to make a request for leave to file a supplemental brief. While an accused has the ultimate authority to make certain fundamental decisions regarding the case, such as whether to plead guilty, waive a jury, testify, or take an appeal, an indigent defendant does not have a constitutional right to compel appointed counsel to press non-frivolous points requested by the client. What do you mean by non-frivolous?
Means non-frivolous. It means an issue that It's technically possible, but not wise to raise on appeal.
Okay, so technically possible, is that, I believe it's my document. Technically possible, when you say technically possible, what does that mean, technically possible? It's possible that it could overturn an appeal, it's possible that it can't. Is that correct?
To me, it means an issue that I can raise, but the court's going to laugh when they get it because it's not reasonably likely to succeed. And I don't like to file issues like that and waste the court's time.
Well, that would be considered a frivolous claim.
No, sir. No, sir. A non-frivolous issue I wouldn't get sanctioned for or reprimanded for. A frivolous issue I might get sanctioned for or reprimanded for because it's nonsense.
Correct. So since you stated that the issues that your client was providing you was non-frivolous, not frivolous, non-frivolous, was it strategy not to submit them as enumerated errors?
Yeah. It was a choice I made in your best interest to try to win the case.
So you decided it was my best interest not to include a violation of the right to be present argument?
Yes, I said that before.
And also you decided it would be to my benefit not to raise the right to the trial by jury?
That's a misstatement.
Sir, just answer the question.
You
decided.
Nobody ever waived trial by jury. You didn't consent to a null pros. That's different than waiving trial by jury.
So, basically, since the state is completely barred, it is true that a null pros without consent of the defendant is equivalent to an acquittal. Is that correct?
I'm sorry, say that again?
It is true that a null pros entered by an accused or entered by the state without consent of the defendant is equivalent to an acquittal. Is that not correct?
I don't think so.
You don't think
That's a loaded question.
Okay, so let me simplify it. When you enter a null pros without consent of the defendant, is that not a violation of double jeopardy if the state turns around and tries to retry you for those counts? Does that not violate double jeopardy?
In certain cases, a case may be tried after an all pros in certain circumstances.
Yes.
So it is not double jeopardy. The normal procedure would have been for the judge to accept a partial verdict and declare a mistrial as to the counts on which the jury was hung. The fact that the judge didn't do that bothered me in this case. Technically, it was improper. Hang on. Nobody violated your rights there, and after the fact, the state null pros a bunch of counts, which is very normal and happens all the time. There are circumstances in which a null pros case can be revived and tried again. The counts that were null pros in your case could never have been tried again, given the verdict on count 6, armed robbery, because it involved the same witnesses, the same victim, the same facts, and you would have won a plea in bar to prevent the prosecution of those 4 counts.
Correct.
So the judge, I don't know what the judge was thinking, but it was a strange procedure, and I tried to make the most of it, and the Court of Appeals spoke to all of that.
Yes, and use your implied consent for that null pros. So when basically, do you remember when the prosecutors, when you asked this question, the prosecutors specifically stated that they didn't motion to null pros. They don't know how the null pros happened. They never written or orally asked for a null pros. Do you remember the state saying that?
Yes.
Okay. So that would contradict the testimony of Mr. McAdams stating that they discussed that once they was leaving the courtroom. Is that correct?
I don't know.
So testimony from Mr. McAdams states that the state and him discussed it leaving the courtroom. It is your testimony, correct, that you're stating that the null pros was done by consent of me. So how can you consent to something? How can you consent to something that you don't know that is happening?
Okay, I never said you consented to the null pros. That's just not true.
Okay.
The thing is, the problem is harm. Whether or not you consent to a null pros, it's a good thing for you. And even if someone made a mistake and you didn't consent to it, part one is the mistake, part two is harm. There's no harm, because you got your cases dismissed.
So the harm...
So, no matter how much me or Mr. McAdams screwed up by allowing null process to happen, that's like saying the client got a bunch of ice cream by mistake and ate it. It's still good for you. So it can't be justiciable, it can't be raised in the appeal successfully because there was no harm. Getting the null process is not harmful.
Even a bunch of ice cream can be unhealthy at some point, is that correct?
Oh, yeah. Let me tell you, I'm way too fat.
Okay. So, in totality, with all of the ex parte conversations and discussions that was done without the client present, in an adversarial process, there are things called frameworking, is that correct?
I don't know what you're talking about. Not familiar with that.
So, are you not familiar with the frameworking of trial?
No.
So, you're not familiar with...
He just said he's not familiar.
Okay, so are you not familiar with certain guidelines or out-of-bounds things that shouldn't occur in trial?
No. I mean, I know of some, but that's too vague. I don't know what you're talking about.
Okay, so being an appellate attorney, not knowing those out-of-bounds or those boundaries that cannot be crossed, that would be a deficiency on your part to not know most of those out-of-bounds.
I disagree.
Okay, so is it not your job to overturn a conviction?
I don't know what you're talking about at all.
Mr. Amos, you've got to stick to what grounds were raised in your petition.
So my grounds was raised that he did not claim these errors, and basically he's under the position that he doesn't know the boundaries that cannot be
I know
crossed.
what you're specifically referring to.
Okay, so when I refer to boundaries, okay, I understand what you're saying. When I state boundaries, I'm stating as far as structuralizing a verdict, coming to a verdict, the reliability of that verdict, and things that can actually make the verdict unreliable. You not knowing exactly what those boundaries are would be a deficiency on your part, is that correct?
Again, I don't know what you mean by boundaries. I know all about bad verdicts, and I wasn't deficient in that regard in this case.
Okay, so having a jury instructed by a bailiff outside the presence of your
We're
defendant?
going to move on from that. I mean,
Again.
you've got something new to bring up. I want you to bring up, but let me tell you what I feel like we plowed the field thoroughly on the hung jury bailiff issue, on the manifest necessity issue, on the supplemental instruction after the Allen charge. I mean, I feel like we have gone over and over and over these issues about whether or not you were present when your attorney spoke to the DA about the null process. If you've got something new to present, I will give you all the time we have, but we've gone over all this for 2 hours.
And Honorable Bryant, what you just spoke on, that is the reason why I was going over that. I just wanted to make sure that you got it and you just confirmed to me.
I got it. I've been listening all day.
Thank you.
Okay.
All right, so, Mr. Clark, basically, I'm going to wrap this part up for you, because I know the state probably has some questions to ask you too as well. Basically, you gamble with your client's rights in order to receive the best outcome in your perspective.
No.
You don't believe that?
No.
Okay. So the issue of the matter is you have a court that sent out an order saying that, the client was completely left out. That's not in your position, that's not a violation of the right to be present.
That's what I said.
Okay. I'm going to close this.
Okay. Ms. Worley?
I have no questions for this court.
Okay. All right. Ms. Clark, thank you for your attendance. I'm very, very sorry that it's taken so long. Have a good afternoon, okay?
Okay, Judge.
Thank you. Mr. Elam, did you have anything further for Mr. Overstreet, or can we let him?
Yes, ma'am. I did want to call Mr. Overstreet up.
Okay, listen, you have got to tailor your questions to what's in that Habeas petition and do not testify. Because if you start doing that, I'm going to shut it down, okay? because we've been here a long time.
And I did want to testify in this case.
But not while we've got him for some questions, okay? Good afternoon, Mr. Overstreet.
Yes, ma'am. I'm sorry, yes, Your Honor.
Okay. All right. I'll just remind you that you're still under oath, and Mr. Ingram, you may proceed.
Okay, Mr. Overstreet? I'm not sure if you can hear me, this mic is off too, by the way.
I hear you.
The battery died in.
Okay.
Oh, is the microphone in? All right, so Mr. Overstreet, questions the trial attorney, and the trial attorney states that you provided the photo lineup of Mr. Payne, is that correct?
Correct.
Okay, and since you are the prosecutor in this case, can you please, if you can, for me, pull up the photo lineup of Mr. Payne?
You asked me that before. I don't have that evidence in front of me. What I do have is I brought up, so we have, in this break, we have a inventory of discovery and certificate of service that outlines discovery that's been provided as well as the date it was. And so on this, I looked through it, and it was picked up by your attorney on January 10th, 2022. In that list, photo lineup number 1, Eric Elam, being the number of the person you were in the photo lineup, number 8, Troy Fetus, and then down below you see 2 other documents that are styled as lineup. So that was provided to Mr. McAdams on January the 10th, 2022. As for the actual photo lineup, I don't have a copy of that. That would be in the archives, which I don't have access to right now.
Okay, what would be the reason that you don't have access to that document?
Because in the archives, it would have had to have been pulled in advance, and I didn't know the nature of exactly what we'd be going through, so I did not have the entire case file pulled.
Okay, Your Honor, now that specific document is very relevant to my claim, and I feel that the state is still at this very moment suppressing that, which is, a hurdle over the procedural default.
Why would you want me to consider that?
The reason I want you to consider that actual photo lineup is that photo lineup shows that I was not identified in this case.
Well, I've heard testimony about that.
Understood, but the actual document being withheld from the jury is exculpatory in aspect of the actual document, and giglio under the aspect of basically not exculpatory, but credibility to the actual victim that testified that said, hey, that's the person. So I have 2 violations, giglio, and I have Brady, from suppressing the document and the actual credibility of the victim.
But you testified about that, but I don't think I need us to look at that photo lineup.
Well, the problem is not the fact that I need you to look at it, it's the fact that I'm trying to prove Brady violation. He is, at this very moment, still suppressing that document. At this moment,
I disagree with you.
I
need to move on.
Listen, I haven't been able to see that document. My attorney never provided it to me. I never even knew it
Okay,
existed.
well, that's the problem that you have with your attorney, though.
Okay.
That doesn't really have anything to do with Mr. Overstreet.
Listen.
Okay.
Now, Ms. Overstreet, during trial, I asked you specifically when I was testifying if you can provide me a copy of that photo
I've
line.
asked you to move on from this.
I mean,
I don't really know what else we need to talk about the photo lineup.
ma'am, I'm just proving to the point that.
You can ask a couple of questions, but we're about to move on from this.
Absolutely. If I can just ask you last couple of questions, we're going to deal with the photo lineup because that's the Brady violation. It's being suppressed. How can you prove it if I can't ask a question about it?
You've asked questions for hours. Go
Yes,
ahead.
ma'am. I apologize, ma'am.
Go ahead.
So, Mr. Overstreet, I did ask you during testimony in this case if you can provide me with a copy of that photo lineup. You answered in the negative. What was the reason that you answered in the negative during trial?
You're talking about during your trial, you asked during my cross-examination of you to provide you with a copy of the photo lineup, into every, so is that what you're asking me?
Yes, sir. I asked you specifically for you to provide that document, and you answered in the negative. What was the reason for you saying no at that point? It wasn't archived at that point, so what was the reason of saying no again?
I'm not in the nature of presenting an evidence that the defendant asked me to do. Your defense attorney could have presented that, and I believe he did question witnesses about that. That would have been something he would have done.
So my question to you again, sir, when I asked you to provide a copy of that document, you said that you could not provide it. What was the reason then for you not to provide it? Was it because you already disclosed it?
It's an accident, so move on.
Okay, specifically about identity issues, okay? You asked the victim if he was able to ID the person who robbed and shot him. Did you know, and I asked you this earlier, but I just want the record to reflect just to see if you knew the answer to the question. When you asked that question, you knew that he was going to point to the perpetrator?
No, I testified earlier, I did not know, and I made the comment, probably not the best thing for a prosecutor to ask questions they don't know the answer to. That's what I said earlier during this testimony, but no, I did not know what his answer was going to be.
And why is that not the best practice for a prosecutor?
Objection relevant.
Is completely relevant, Your Honor?
I'll,
Typically don't ask questions you don't, I'm sorry, Judge,
go ahead.
Typically don't ask questions that you don't know the answer to as a part of what, most attorneys won't do that. You don't want to elicit information that you're not prepared for.
And when, as you're a prosecutor yourself, when you ask questions that you don't know the answer to, is that how you find the facts?
Is that what?
Is that how you conduct finding facts? Asking questions that you don't know the answer to?
Very rarely, but occasionally you have to ask a question. You have to be nimble, as an old judge told me in the trial, and you need to be able to adjust and be flexible. I was confident in the evidence that we had, and whether he identified Mr. Elam or not as the perpetrator of this offense, I believe the evidence, that's why I went ahead and asked the question, despite probably my better judgment.
And what was your reason of not asking Nigel Kennedy that same question?
We spoke about that earlier too. The position of Nija, she had this secondary subject, which is Mr. Fetus in the back seat with her. She specifically in my trial prep mentioned that the person in the front seat did not turn around. When I prepped with her at the Cherokee County Adult Detention Center, I asked her questions about that, and she could not identify who it was. She only saw a side view, and it was dark. Again, this happened in the evening, so she was not in any way able to give me any description, unlike Mr. Fain, who had a side profile and mentioned that, person with had glasses on, and nobody in the photographs had glasses on. So that is part of the reason why I felt more comfortable asking him. Just instead of Mr. Fain, happened during the daylight hours. He had more interaction with the driver of the vehicle, which is the person who shot him, whereas Ms. Kennedy did not. So given those factors is why.
And you say that he had a side profile. Now, during that, not to speak on about the photo lineup, it's just a question about his conduct. During that photo lineup, was he able to positively identify Mr. Eagle?
No, I don't believe he identified anybody in the photo lineup.
Okay. So that document would be exculpatory, is that correct?
No, this is what happened here, sir, objection more than thanks.
Okay. But you said he didn't identify. Now, since you knew that he didn't identify, you can easily say that you should have known the answer to the question when you ask the victim if he can't identify the alleged perpetrator. If you say that he did not identify anyone, you knew the answer to the question. Is that not correct?
No, that's not correct.
Okay, so if your alleged victim says that I can't identify anyone, when you ask the question in the courtroom, can you identify the person that robbed and shot you? If you already presented the defendant to the victim and he failed to ID, this is the same person, is it not?
Same person that is in the photo lineup, or the same person who is asked to identify the person? Yes,
that is the same person that you tried in trial is the same person that you presented in the photo lineup, is that correct?
I'm confused. The same person that I tried, being you,
Yes.
same person that was he showed a photo lineup of that person?
Of me?
Yes, I'm confident that you were in one of those photo lineups that was shown to the victim.
Okay, so you're confident that the same person that was tried in this case was showed in a photo lineup, is that correct?
I was not present, but yes, based on the report of I believe it was Investigator Harris and how photo lineups work, then yes.
Okay, and I would like the record to clearly establish or state that you did say there was no positive identification of the petitioner.
I think I've stated that pretty clearly a couple times, but yes. Nobody identified you in a photo lineup.
Okay, I just wanted the record to be clear. And the reason why I asked is because there was a conflict of interest. Do you not remember? Okay. Do you not remember that the court touched bases on a conflict of interest with Mr. McAdams before trial started?
No, if you want to refresh my recollection, I don't recall conflict of interest from the being brought up.
Okay, so do you not remember the court stating that there was a couple of filings for Mr. Clark, or Mr. McAdams to be released from the case? Do you not remember that?
Oh, I've been specifically until you mentioned it, no, but I do remember that there were a series of filings. You were unhappy with Mr. McAdams at the breakout. I don't recall if you had mentioned that there was another attorney that you were trying to hire, but you did not want to go to trial that day, absolutely.
Okay. And do you remember the court ever asking any questions to determine exactly what that conflict was?
Not specifically, no.
Okay, so the court did not ask what the conflict was?
I did not say that. I said I did not recall that they asked any specific conflicts.
Okay, so I would like the record to reflect that it doesn't show that any questions was asked about the conflict. So, since the conflict wasn't discussed or disclosed, as a prosecutor, is it easy to say that, you know, the defendant in this case was forced through representation since there was no disclosure of whatever conflict it was? Is that not correct?
I would object, first of all, since that common evidence, Mr. Overstreet, questions, and then also ask Mr. Overstreet to opine about whether or not Mr. Elam was decided to select the investigation.
So, which, I can use, is it okay, I use the transcript from trial? Because I have the transcript from trial,
What ground is this in?
this is under the grounds of prosecutorial misconduct, of him having information submitted to his office, and he didn't investigate it, he didn't ask any questions. His duty of finding conflicts at his very earliest earliest moment.
Conflict between you and your attorney?
Well, conflict, period. The conflict of the case, conflict.
What is all that?
This is the transcript. This is the trial transcript.
From what?
The trial transcript.
Has that got some bearing on his prosecutorial
Yes,
misconduct?
ma'am. He was there for the proceeding. He overheard exactly what.
I'm not gonna you can ask him questions, but, I mean, you've already asked him, you've had a thorough examination of him earlier. Now you're going over brand new ground. Just ask him questions, okay? If you've got something new to ask him. But your conflict with you and your attorney,
Has nothing to do with Mr.
I'm not sure how you are trying to say that he was guilty of prosecutorial misconduct, but
Well,
let's move on.
the
Just ask him
reason why I
questions.
asked-
You're gonna ask him questions while we have him here, and then I'll let you talk later, but, ask him questions. He's been on this call since 9 o'clock this morning.
Listen. So, Mr. Overstreet, you basically, I didn't ask the question 1,000 times, I understand that, I would like the record to reflect that. The reason why I'm not getting off of that issue is because I believe, and I still believe to this day, that you're suppressing that evidence. And what I'm trying to establish is, it was a collusion between you, Mr. Overstreet, Mr. McAdams, and Mr. Clark,
Judge, I would object to Mr. Gillum testifying if he wants to ask Mr. Overstreet if he colluded with someone, that's okay, but I would object to him testifying.
Remember what I told you, if you don't ask him questions, I'm gonna dismiss him from the Zoom hearing. He's got to ask questions. Okay.
Okay. Did you speak with Mr. McAdams during the pendency of this trial?
Multiple times, yes.
And did you speak to Mr. Clark during the pendency of this appeal?
Less than Mr. McAdams, but it's not uncommon for an appellate attorney to reach out, maybe help seeking specific piece of evidence or things like that. So I would say I probably did speak with Mr. Clark, yes.
Okay. And when you spoke with Mr. McAdams, did that conversation have anything to do with no processing charges or anything like that?
Before the trial?
I'm just asking about the conversation. Did you speak to Mr. McAdams about no processing charges?
There would be two instances potentially. I know after the trial, when it was a split verdict, Mr. McAdams, I believe when we were walking out of the courtroom, asked if I was going to try you again for the remaining counts. And knowing that you had a prior felony conviction and we had a conviction for armed robbery, that the sentence would be life, I did not think that it would be in the interest of judicial economy to do that, so I told him no, I would not be proceeding with charges, the remaining charges.
Okay, and did you specifically say...
Before trial? Okay, sorry, go ahead.
Did you specifically say you didn't intend to retry, or did you specifically say that you were going to no process the charges?
Specifically said I was not going to retry the case. We weren't going to retry the remaining counts.
And what does that mean as far as the prosecutor? Does that mean you're going to dismiss the charges, or what does that exactly mean?
Yes, that's what that means. I mean, again, we're in dealing with Mr. McAdams and attorneys. They understand that if I'm not going to retry the case, the only option left would be to be a dismissal. That was clear to Mr. McAdams at that time, and based on his testimony at the motion for new trial as well. That was what it was clear to him as.
Okay, so when you say dismissal, what type of, that's what I'm trying to get from you. What type of dismissal? Is it acquittal, a directed verdict of acquittal, or is it a no process? What exactly was your intention to not retry those counts? Was it to no process, dismiss them by acquittal? What was your intention?
The only way that I can get rid of charges at this point would be through a no process.
Through a no process? Okay. And during the motion for new trial, you specifically blamed probation for the entry of no process. What was the reason of blaming probation?
Probation put on the face of the sentence that it was no process. That had not been done yet. And so that is, at the time that we did the sentencing hearing, probation put on the sentence that it was no process. The actual filing, which is a document that must be filed with the court, presented to the judge and signed by the judge, had not been presented. So that is why we're in that posture.
So at one point you accepted what the probation had entered on that document as no process. Is that correct? Because in your brief to the appellate court, you actually went under the position that you accepted that no process. But under your motion for new trial, you stated that you don't know how it was entered. So did you accept the benefit of a no process, or do you deny the no process? Which position are you under?
Well, the only person who would benefit from the no process would be you, Mr. Young.
No, I'm asking which position are you under? Did you intend to no process the count, or are you under the position you don't know how they happened? Which position are you under?
I think you're arguing two separate things. You're arguing about the sentence reflects a null process. That is not signed by me. That is signed by the judge. And in null process, I'm required to enter an order before the judge. That null process would have my signature on it. I believe that was eventually filed, but it was not done before the sentence had been come down, where probation wrote the sentence that reflected null process.
Okay, so you said it was
filed. That was not signed by me.
Okay, you said, okay, but you did say it was filed at one point. Was that done on the record?
I believe there was.
Was that done on the record with the defendant present?
I do not recall, Mr. Young.
You do not recall? Why do you not recall that? That is a very significant issue. Why do you not recall that?
I don't want to be rude, Mr. Elam, but that's not a significant thing for me. I handle a lot of trials, and so we're getting into very nuanced things that I just don't recall the timing of who was there when a no process was submitted or not.
Okay, but under the motion for new trial, you specifically stated that you don't know how it was entered, you don't know when it was entered, you didn't make a motion to enter it, nor did you orally request it to be entered. So how can you reap the benefit of those charges being no cause while under the position of saying you don't know how it was entered?
I believe with that motion for new trial that you're talking about was referencing in response to the argument that it was on the sentence, not the subsequent motion that I signed.
So when did you sign that subsequent motion? When was that signed?
I don't have the date, Mr. Young.
You need to tailor your questions to any kind of obstacle.
Yes, ma'am, and that's prosecutorial misconduct because the statute 17-8-3 requires, after jeopardy has been attached to a case, it absolutely requires the consent of the defendant. And for him to sign an order without the defendant present, that is prosecutorial misconduct. That is the abuse of power. You cannot sign that order without getting consent first from the defendant. Is that not correct? So at the end of the day, he's testifying that he's signed an order of no cause without anyone being there, and also under the notion that he don't even know how it was entered. So you can't be under both positions. You can't say that I don't know how it was entered and be under the position of saying that I signed for it. Those are two different positions.
All right, let's move on.
So that's prosecutorial misconduct.
All right, let's move on.
So, Mr. Overstreet.
Yes.
Okay. At one point, there was an instruction given to the jury, okay? And you were the prosecutor, most of the time, you are in the courtroom, is that correct?
Correct.
Okay. During the time that the jury was hung, what did the judge give to the jury to help them break that deadlock? What did the jury request for to help them break that deadlock?
Typically, what you're referring to is what's called an Allen charge.
An Allen charge. Do you remember there being a lunch break?
A what?
A lunch break?
I'm sure we had lunch that day.
Okay, and which happened first? Did the lunch break happen before the Allen charge, or did the Allen charge happen before the lunch break?
I can't tell you which one occurred first.
Okay, so I can tell you that the Allen charge happened before the lunch break. Now, after the lunch break, the judge instructed that the jury would be given an opportunity to restart their deliberations after the lunch break. Who decided not to allow them to re-deliberate?
I'm sorry, you said we took a lunch break and then they started deliberating, and then what? And then who decided not to allow them to deliberate?
I stated that the jury stated that they were hung, and then they sent a note asking for a lunch break, and the judge specifically stated that, hey, I'll give you 30 minutes to have lunch, and only when 12 of you return, I'll instruct you to restart the deliberations. After that lunch break, the judge didn't allow them to re-deliberate. Who decided to stop them from re-deliberating?
Stop. I don't know what the question is. You're stop them from deliberating after lunch? I'm not tracking you, Mr. Young.
Whose decision was it to stop the jury from deliberating after their lunch break? Whose decision was that?
I don't know. I mean, the judge runs the courtroom, so I don't quite understand what your question is. Who stopped them from deliberating, like prior to their verdict, or?
Let's just say that. Who stopped them from deliberating?
I still don't understand the context of what you're asking, Mr. Young.
Who stopped the jury from deliberating?
He told you he doesn't understand the context.
So,
what does this have to do with if the judge instructed the bailiff to hold the jury, to ask the jury where they were, what does this have to do with Mr. Overstreet?
The reason why he's involved is because the record shows that on the motion for new trial, the trial attorney testified that Mr. Overstreet, Mr. McAdams, and a judge discussed that matter, that specific
We can
issue.
get to the point.
Okay, so
You're
that's,
asking him all these
that's what I'm trying to ask him.
wasting our time.
so Mr. Overstreet, during that, after that lunch break or before the lunch break, when did that discussion occur that, hey, we're just going to accept what the jury has and stop deliberation? When did that discussion occur?
I mean, sir, I don't recall on part of the day, obviously. I mean, I don't know, Mr. Young. I don't know when it occurred. I vaguely do recall there being a conversation, Mr. McAdams being there. I believe they did figure out that the jury was split. I think it was through a note. Obviously, that's the typical way that's done. The jury doesn't come out and say where they're at in front of the defense and state and anything like that. It would have been through a note indicating to the court that they were had a unanimous verdict on some aspects and not on others. But the timing of that, I don't know, but I do vaguely recall the court indicating that he was going to allow the jury to continue to deliberate a little bit longer, but if they're still deadlocked, that he would accept a partial verdict.
Okay, and the state has...
The timing, I do not know, though.
Okay, and the state has the responsibility to make sure that that note is a part of the record, the exhibit?
Do I have that responsibility?
No.
We submit all the evidence together, so, yeah, yes, sure.
Okay, so the state does have the responsibility to make sure that any type of note from the jury that's dealing with the verdict is a part of the record. Is that correct?
Sure.
Okay. And it's clear through the record that that note was not made a part of the record. Is that correct?
I don't know that.
Okay, I would like the record to reflect that that note is not a part of the record. Okay, so the judge decided to stop the jury from deliberating. At what point did you feel as a prosecutor that it was improper for that discussion to be happening without the defendant present? At what point did you feel that that was improper?
Never.
So you didn't feel that it was improper to leave out the defendant from discussing substantive matters?
I don't believe these are substantive matters. These were just a matter of the court administrating how it wants to administrate his courtroom. And all the times that the jury had notes, you were made aware of those. While you were in the courtroom, you were aware of what he had said, and he made you aware he's going to allow you to continue to deliberate. So I don't believe there's any violation, Mr. Young.
So just a quick question, and I can close with this because I want to get into testimony. It is an administrative issue for a judge to instruct a jury how to fill out a verdict form. Your position is that it's administrative?
Fill out a jury form, that happens all the time. I believe we had a verdict form in this case. The judge typically outlines what that is going to entail so the jury can understand. So, for example, I'm actually looking at the jury form now. It has multiple counts on there where it has two options, guilty or not guilty. The judge will explain the process, as they go through and how they need to render a verdict on each count. It must be unanimous count, part of the jury charge that the judge gives.
Okay, so I'm glad you just said that. You just said how to render the verdict. So if you were to explain to a jury to leave part of the verdict form blank, is that not substantive to a verdict form?
I would never instruct a jury to leave a verdict form.
Is that substantive to a verdict form to instruct them to leave it blank? Is that not substantive?
Judge, I don't know if Mr. Everson's opinion on that is relevant to this case.
Okay.
I have no further questions, Your Honor.
Okay.
I feel
Anything
like
further?
No, Your Honor.
Okay. All right, Mr. Overstreet, thank you so much for your participation today.
Yes, ma'am.
Thank you.
Thank you. Am I excused?
Yes, sir, absolutely.
Thank you so much. Have a great day.
I would like to testify. I think I can give a lot of...
So, is there another?
You swear upon the testimony you give, the truth, the whole truth, and nothing but the truth, and nothing but the truth.
Judge, I just asked for the sake of my objections that we make sure we keep this section of testimony and not arguments, and then have argument later.
Is that kind of what you were planning on doing, is just testifying to your grounds, or were you?
Yes, ma'am. Now, as far as, obviously I'm representing myself, so cross-examination and then direct, how do we go about the cross?
Well, I mean, if you're going to testify, then she will be able to cross-examine.
So that would be direct, would it not?
What's that?
That would be, that would be cross, but as far, I'm sorry, I asked it wrong. As far as direct examination, how would we go about direct?
Well, I mean, you just basically just tell me what you want me to know.
Okay, yeah. Can we do the cross first?
No.
Okay, so, basically, Your Honor, during the trial, way before the trial started, without any implication for me, the attorney found that it was reasonable to tell the judge that, hey, we've been having issues. I filed multiple different filings to the court stating that he was making up evidence, and I tried my hardest to inform the court of that, and the only reason why they denied the first time I informed them is because I had no proof that he made up evidence. So for the longest, when I was in the jail, I kept asking the jail to, hey, I need you to produce my church transcript. I need you to produce, and they kept throwing me off, saying you don't have money to pay for it. You got to go through the attorney. You got to submit an open records act. I would go through him, and for the longest, he kept pushing it off like, no, I'm not doing it. I'm not doing it. And he knew why, because of the text messages and what it entailed. So eventually, I filed a bar grievance on him, and that propelled him to do the open records act. And when he filed it, I got a copy of it. I got the messages. I presented it to the court for evidence today, that he specifically said that I was identified by all of the victims in this case. I did not want to be represented by that attorney because that specific reason that I was not identified in this case. And for you to say that is a complete conflict. You're saying I'm identified. The evidence is saying I'm not identified. That's going to alter your representation. That is, at no point am I benefited by that type of representation, having a client say, hey, you're identified, and I have evidence showing that I'm not identified. There's no type of benefit of that. And when I submitted it to the court, I didn't have the evidence that I needed to show that he was making up the evidence, so they denied it for that. Once I actually got the evidence, I tried to explain to the trial court, and they completely overlooked it because they said that it has already been ruled upon. Yes, it's been ruled upon, but it was before I had evidence of him making up evidence. You know what I'm saying? So I never been given an opportunity to show the actual conflict. This is the very first time that I've ever had the opportunity to present these claims because of the ineffectiveness of both of these counsels. And I've tried multiple different times through multiple different remedies to get these counselors off of my case. And they each told me, you can hire whoever you want to hire, I'm not leaving your case. I have the right, at some point, if I don't want your representation, I have the right to represent myself. If I choose to represent myself, there should be a hearing given to see if I'm competent enough to represent myself. I've never been given that opportunity to show that I'm competent enough to represent myself, so I've been forced to have these counselors as my representatives. And it's clear as day that they are choosing arguments that is clearly weaker than what the court has already admitted to. It's a presumption of prejudice. I don't have to prove that the outcome would have been changed. Just the fact that you instructed my jury through a bailiff, either administrative or through substantive matters, is presumed prejudice because it's done off the record, which makes the verdict is not reliable. It's not reliable. And to say that, I'm telling to say I am not a part of this case, I'm not a part of this case, I'm not a part of this case, I'm not identified, and to go through this procedure and to have this type of representation and deprive me of my rights, like, when am I ever going to get the opportunity to be restored my rights? I have a right to be innocent and to proven guilty. I've never been proven guilty in this case. You cheated the adversarial process when you injected into the jury room and instructed them, and then all of a sudden there's a verdict. As soon as you give them an ex parte communication, all of a sudden, boom, there's a verdict. Before that ex parte communication, they're hung. And not only hung, but they're hung on these particular charges that are intertwined with each other, that require each other in order to come to this verdict. It's inconsistent, it's not reliable in no shape, form, or fashion. And to have the state relying on procedural default, to say that, hey, you know, you didn't argue these, it's clear as day that I did. I submitted it to the Court of Appeals. The Court of Appeals concludes that, hey, no, you're representative. We can't answer to these errors. You have to go through your counsel. I go to my counsel with the email proof here today, and I asked him, hey, supplement this. You're saying this, that's absolutely wrong, that's against my interest, that's against it. You need to supplement it. And he's saying, well, I don't find it valid. I don't find reasons to supplement the record. I found no grounds, but your response to the bar is saying that the grounds are non-frivolous. So even if, you know, enumerated errors is a possibility. You said it in your testimony, it's a possibility that it would have changed the outcome of the appeal. And in the Habeas Corpus court, that is something that I have to prove, that it would have changed the outcome for ineffective assistance of the Appellate counsel. So that's the probability. Why not ask them as enumerated error just because? Why say, you know, well, my argument is stronger? You know, we're not in a performance debate, or, you know, my claim is better than your claim. We're just trying to claim anything that has some sort of merit to show the court that the adversarial process has been broken, that the evidence is weak, that, you know, the trial is unfair, and the record itself shows that I was excluded on all the critical points of this trial. Okay, you know, during the normal phases, it was okay. You know, I questioned the boy Dyer a little bit because the foreperson actually disclosed that she was close friends with the prosecutor sheriff's office, and after research, I found out that same person she said she's close friends with publicly spoke about my case. And to just ask her if she's going to be biased, and she said no, you know, how can you determine that, you know, she's being honest unless you ask her further, you know, well, what is the nature of your friendship? Like, what do you guys normally speak about whenever you're in her house or in his house? What do you guys speak about? You don't know if she's being honest. So you're trying to rehabilitate that juror. And it's completely ineffective of my counsel not to strike her for cause, just to avoid the appearance of impropriety. That's an appearance. Even if it's not an impropriety, it's an appearance of it. The judge has a duty to avoid that appearance of impropriety under the canon. So it's like, at what point am I going to receive a fair trial? If every point you're overlooking these rights, you're overlooking these rules, you're overlooking these canons, you're overlooking the code of conduct in order to get this conviction, the conviction is not reliable whatsoever. And I feel that for the state to first file the answer rate is an issue, and also for them to not go to the merit of the claim, for them to be claiming procedural default after seeing the claims that these attorneys chose not to actually submit them, and I told them to submit them. That shouldn't be an affirmative defense that the state can rely on. That's a violation in itself for them to rely on a procedural default. And it's a violation of them to not even give me the opportunity to subvert against that. Like, if I didn't have the necessary tools that I have, you know, as family members and stuff like that, I would have never known that they were dependent on Black versus Hardy procedural default. So I'm at a complete disadvantage just off the strength of the state doing that. And I believe Ms. Worley knows exactly why she chose to file her answer on the 19th, a couple of days before an evidentiary hearing, on a Friday. The petitioner is incarcerated, so first of all, you have to calculate the time of being a weekend. Then you have to calculate the time of the mail has to be inspected for security, compared to a hearing being on Tuesday. When are you going to give me the opportunity to say, hey, you can't rely on that? So, I've been at a disadvantage from the trial. I've been at a disadvantage from the beginning of this case all the way to habeas corpus. I've been disadvantaged, put in a disadvantage. So for the court to not recognize that, or to act as if no offense, Your Honor, to act as if it's not a thing, that is a miscarriage of justice. That's something that, it was completely, it would make the judiciary seem, untrustworthy. Like, you can't trust them. So they can do whatever to you, say whatever, and uphold the verdict. You know what I'm saying? So, I don't want to say too much. I feel like my issue has been pointed out. Is that, the state has been disadvantaged, putting me at a disadvantage throughout this whole entire procedure. It's very unfair for the state to rely on procedural default, and it's very unfair for the state to use that, knowing that these attorneys chose to do what they did and gamble with my rights in order to get an outcome that they felt would be beneficial to me. That's not what the Constitution stands for. The Constitution doesn't stand for, hey, we're going to gamble with his rights and hopefully the outcome comes out good. That's not what the Constitution stands for.
Do you want to, do you have any cross-examination questions?
No cross-examination.
You don't have any questions. I'll tell you what, I do see that the return of answer was filed February 19th. I don't mind if you want to, maybe give you 30 days to respond to this. I don't mind doing that.
No, I just moved the court to find them in contempt for the work. The reason why I say that is because they have a 20-day deadline.
And the reason I'm not going to do that, though, is you have filed so many amendments to your petition. So she was probably trying to respond to all the different amendments. I can't speak for her. I'll let her speak for herself. But I'm just saying that you were also filing things up until the 20th. So it's kind of disingenuous for you to point out that they were late filing, but then when you've kind of also been constantly filing things.
Okay.
But I certainly don't mind at all giving you 30 days to respond to this return answer. I can hold off on doing anything until you have a chance to do that if there's something that you're interested in.
Well, as far as the miscarriage of justice, I feel like it would be very, very harmful of me to delay, the determination of miscarriage of justice.
Okay.
So
let me point this out to you. This hearing, I don't know if we've been going for 4 hours or what, but I can't issue an order until my court reporter gets the transcript done. And so that's going to take a good bit of time. So if that's something that you're worried about, and if you want the 30 days to respond to their return answer, that's fine. If you don't, that's fine. I'm going to leave that up to you. But it is going to take Ms. Hay longer than 30 days to get this transcript.
And I understand. I do not want. She's the most important person to me.
Yes, sir.
But what I do want the record to reflect that the Attorney General did not answer to all of my claims. I think she consolidated the remaining of my claims from ground 13, I believe. Because at one point she just said the rest of the grounds, I just dismissed. I'm asking. She didn't even claim anything. I'm not sure. Do you have that? Because I don't have a copy of it. I don't know. Do you have a copy of your?
I have a copy that's been written on. It's a boilerplate, denies each and every allegation of petition not previously been denied, otherwise constituting boilerplate. I responded to all of the amended petitions that we had in our office at the time. When I went back to the office on Monday, I found that we had received, I think, the one that was filed on the 2nd. I don't think we have received a copy of the one that was most recently filed.
Okay.
So I'm happy to just respond to that in the brief or the proposed order. There might need to be a copy.
So the one that was filed on February 20th, that's, because I understand that the court doesn't allow ineffective assistance to be a standalone claim to overcome procedural default. If I'm wrong, but I made, just to make sure I'm crossing all my T's and dotting all my I's, I went on and filed ineffective assistance to overcome the procedural default, which is the last filing on February.
I understand that. That makes sense. All right,
And just before I move on, I want to make sure we get our documents and everything.
sure. All
I
right,
don't know.
that's fine. I tell you what, do you still want some time to make a closing statement, or was that kind of your closing statement that you just made?
Well, the testimony that I provided, that, that is really, is more to it. I don't want to delay the court, and I don't want you to.
But this is your day in court, so I don't want to keep you from thoroughly going, having your time. So.
I just know that sometimes, I have an issue. I'm not going to sit here and act like I don't have an issue. I have an issue with repetitive, saying things over and over when I feel like my point is not coming across. So during my testimony, I just wanted to make it clear that these errors that was supposed to be filed under Georgia law, the Appellate Court has ruled on it, the Supreme Court has ruled on it, the U.S. Supreme Court has ruled on it. Even if instructions are administrative, it's not necessarily the instruction, it's the timing of the instruction. And to say that the jury has already declared themselves to be hung on certain counts and you're given an Allen charge, any instruction after that an Allen charge is very, very, it's actually scrutinized by the courts a lot more because the jury, they're in a position where anything can change, can sway, can move the verdict. So by being off the record alone in Lindsay versus State, that is a presumption, regardless if it's administrative, regardless if it's substantive, it's presumed precedent.
Okay.
So I feel that it's necessary to put on record in front of the judge, as far as making a record of that is the actual definition of a miscarriage of justice, to deprive somebody of their right to be present in a trial. That's unfair. There's no trial ever. You heard testimony from the appellate attorney. No one has ever seen a trial ended in this fashion. This is the very first time in Georgia that a trial has ended like this, without no verdict, without no declaration of a mistrial, without no consent for the null process, without even a motion being made for the null process. This is the very first time that this has happened. And no consent for the null process alone is a violation of my rights. Me not being present during the discussion of that is another violation of my rights. Entering it without my consent is, so it's an ongoing issue, and it's going to continue to be ongoing no matter what court this is in front of. It's going to continue being a miscarriage of justice. From the trial court all the way to however far this goes, at one point, Your Honor, it's going to have to be answered to. You're going to have to answer to that because it's a constitutional right of mine that I did not waive. It's no record. You can't use the state cannot rely on the silent record to say that, you acquiesced, you were silent. I wasn't. I complained about it. I was barred by an outside thing. The state barred me from submitting it. The state intervened in my case and stopped me. And, the Georgia Supreme Court released in 2023 that hybrid representation does not stop an individual from filing pro se motion. So I feel that the court erred by not allowing me to preserve my rights. And, just again, I'm going back over the same thing because I want the impression to be made that, you have actual innocence issue and then you have a miscarriage of justice issue on as far as the fairness of the trial. So both prongs of the miscarriage of justice have to be satisfied. And, you know, you have to necessarily put yourself in my shoes in order to know what I feel like. That, you know, you took me through these trials, man. You took me through these trials without giving me my rights. And said that I did something that I didn't do. And you continuously saying, you was there. You bought testimony from a accomplice that you threatened with a life sentence. I'm going to give you a life sentence if you don't testify against this person. I'm going to give you a life sentence. You bought that testimony. You bought the testimony from the victim that you admitted to selling drugs and that you didn't charge him. You bought that testimony. You heard from the testimony that...
in your petition?
Ma'am?
Is all this in your...
All of this is in my petition, and all of it. That's why I admitted it so many times, because I wanted every ground, every single ground to be heard. Because just one of these grounds, just one of them, is enough to overturn this verdict. It's enough to overturn this verdict. Just one, just the point of the matter that discussions to a hung jury was done outside my presence is alone enough to overturn my verdict. Just the point of me being not identified in this case and me telling you that I wasn't part of the case and me giving you the report on the car being stolen and you suppressing that from the jury. You're not presenting that to the jury, regardless if it's partial. It's clear as day that the victims did not identify me and they played with words, how they've been playing with words to get a conviction. And I feel like that is unfair. It's unfair for you to play with words like that when you're dealing with someone's life, especially with a life sentence. It's not like I got a 20 to 12 or I got a life sentence. I have to be in prison. That's luck. Inshallah. I have to deal with the life sentence from these errors. Put yourself in those shoes. That is very, very, very traumatizing. That's very traumatizing. And to say that you injected my name in this case over, and you've seen it for yourself today. You was in the car. You've never proved that. I've told you over and over and over. Your alleged perpetrator is protecting the person who was there. I kept telling you that. I kept saying that. You never interviewed me. You never came to me and said, "Hey, Mr. Ewing, give me your version of events. What happened?" I never been given that opportunity. So I took it upon myself to get understand and to explain to the jury that, hey, this is what's going on. And guess what? Every single time, strike that from your mind. That's not evidence. Strike that from your mind. That's not evidence. Every time I said I was not identified, strike that from your evidence. Strike that from your attention. It's not evidence. How is not evidence when it's evidence? It's evidence that I was not identified. So how can you strike that from the attention of the jury? So now when they go back to deliberate, they're going back to deliberate under the impression that, hey, this person has been pointed out, this person has been identified as the person of these crimes. They've never been given the opportunity to actually decide the credibility of this person who has been found to lie about the case. You first lied about what happened. You first said, okay, you went to sell shoes, and then you turn around and said it was a marijuana deal, all on a person that wasn't there. Like, you have to understand that is not right. That's not right. Put yourself in that shoe. I'm telling you, this person is lying. He's showing you that he's lying. So where's the fairness?
Okay. All right, Ms. Worley, do you have some documents to send? Yes. Response 1 is the record and record index from the Court of Appeals. Response 2 is a transcript from the hearing for trial. Then respondent 3A is most of the trial transcript I could get in one of the binders.
They don't have Fulton County in it. I'm not sure if I ever had a case in Fulton County.
So 3B is the second volume of that document.
Yeah, this one right here. What is this right here? Because I didn't have a case in Fulton County.
This is someone's resume, basically. Like that.
Okay, okay.
Respondent 4 is the motion for the trial transcript. Respondent 5 is the court of appeals. The appellant 3
That's what I wanted to do.
Respondent 5.
Okay,
Respondent
this
6
is the part.
is the state's response. And then respondent 7 is the court of appeals actual.
So, am I still under testifying?
No, I thought you were done with that.
Well,
Do you have any objections to any of these documents? That's not where we...
yes, ma'am, I do, I would object, to the page not being admitted into evidence. If this is what's occurring right now, I would like for this specific page to be submitted into the evidence of where the trial,
I'm asking for the entire opinion to be submitted into the evidence.
Okay, great.
We're asking for all of it to be submitted into evidence so the judge has access to the transcript and to the opinion so she can see all the things you've been referencing in court today.
Yeah, I'm trying to find this specific page and to make sure that is in this document. Where the court relied on this specific wording.
Did we ever get that copy?
No, we never did.
You were waiting on me, okay.
Yeah, I can go get it done right quick.
Are you thinking about that transcript that I had?
I'll try to find that one for you while you're doing it.
Yeah, it's where it says, why it is likely. I think it's page 7. Yes. It is page 7? Yes. Ms. Barnett, I appreciate it. I do. It's not in order for
All these?
Yes, sir.
Okay, well, did you have any objection to any of those documents going out?
Well, I saw the order from the appellate court. I don't believe you would take out any page or...
This is basically the entire record that was submitted to the court of appeals. We just asked them to print it up, we printed it out, and that's what we're doing.
So these are all the ones that I submitted for this court.
So that was the records that the county where you were tried, they sent that up to the court of appeals. So that's everything that was sent up on your appeal.
Okay, so this one looks like, this looks like the grounds that I submitted to this court, that's why I asked that. Yeah, these are the grounds that I submitted to this court. Okay, so that's even better. It's one that I tried to submit it.
Yeah, usually, everything that they have is very beneficial. I mean, it helps me see what's happened up until this point, you know what I mean?
There's so many things that have happened throughout this pandemic. I just want to make sure because, you know, it's so many odd things that go on.
Yeah.
And specifically on page number... Right now, for this, is there any way that I could submit other documents that have not been submitted to as well? Or?
No, I mean, usually, everything would have to be submitted during the hearing.
Okay, that's what I'm saying. The ones that was submitted during the hearing, is it okay that I go ahead and provide the copies of those, the ones that was submitted?
And the only thing you need is the Yeah, the only thing I did was
With this,
that transcript from the probable cause.
so you never ruled on, yeah, approach?
Uh-huh,
And I showed her a copy, I got a copy for her too as well, if she needs one.
okay.
And this is directly,
This is the grievance that you wrote to the bar about,
yeah, specifically about the same exact errors that the petitioner's claiming today.
And we objected on, hearsay or anything like that.
I don't remember if you sustained that objection or if you limited the scope of it.
do you have a copy from Ms. Farley?
You just, I didn't want to.
I'll take a look at it. I'll take a look at it, I'll look at that, yes, I'll let
You
that.
want to, or?
No, she's gonna give me that.
Okay.
And I'm putting the preliminary hearing in chronological order.
Okay.
Now, it has the markings on it, please don't mind that, it doesn't need highlighting, you know, the specific points of where. And also, we did admit the denial of the Court of Appeals, taking issues, those were admitted, so is it possible that we might need a copy of that too?
I don't think I admitted that.
You did?
Ms. Farley, I don't think we admitted anything from the Court of Appeals.
No, I think we kind of left it at, me saying that all it was a remitter that I was not going to object to.
Yeah, do you have the remitter?
So the remitter, I never received a copy of that from the attorney, but I do have, you know, since the state is relying on procedural default, I do feel like it's relevant for you to inspect it in camera, as far as the denial of the Court of Appeals hearing the same exact claim.
If it's communication from the Court of Appeals, I don't object to it.
Okay.
Yeah, just direct from the Court.
All right, I'll admit it as P3 if Ms. Farley doesn't. If they don't do it. Do you have copies of those things?
I don't. Is it possible that you, I don't even work, what's your name? I don't know which one you want. So, I want to tell you this copy.
Dang, I love it. Now, Ms. Farley, when you didn't have an objection, were you speaking of just the correspondence where you received from the court, or
Correct.
received from the Court of Appeals? Because I think he's trying to give them other.
No, these are, they come together. So they
I
were
just want
filed,
to make sure she's saying all of
listen,
them.
they were actually filed in the Court of Appeals. So this is their correspondence.
What did you want to see? What did you want to see? The grievance letter from to the state bar, or, yeah.
Is this all for the same thing?
Yes, and so they happen theoretically, filed it once and then they denied it again. Each one is a response from.
I wasn't already out. Was there any other objections to the?
One second. Let's wait for this. Make sure that you see all of it.
I'll make sure they're in the right order. So it makes sense. So would that fall behind this one?
So I gotta see the date. Motion to withdraw. So we just put this one. September 23rd. September 23rd. This one. October 13th. And put them like this. And one of these, the actual document was used in the Northern District for a lawsuit that I have on these same individuals. So I used a copy of that, the original copy. So one of these doesn't have the actual filing for it. It's the court's response.
it's all the same issues that you're raising, so, right?
And did you have any objections to the state document being reviewed?
This one, no.
Which one is that?
This is R1, it's the record.
R1's in the without objection.
So this one is for outstanding motion hearing?
Correct, those are the three motions that were heard before trial.
The only objection I would have to this specific one is it doesn't have the part of the transcript where there was discussion about the conflict between the two.
Did that happen on that particular day?
Well, this one is right before this, and I believe this is the trial transcript, is this book?
Yes.
Yeah.
So those two big ones are the trial transcript.
Yes, it completely skips over.
So this one here on the podium is not from the trial transcript. That's from a separate day where there was separate hearings on the intrinsic evidence issue and the 404B
Yeah, this
issue.
is before trial. I believe my only objection to this would be that the actual motions here, not all of them was answered to. And you'll see that here, which is part of the transcript, the trial transcript in the beginning, it explained how some of these motions wasn't answered. So,
Okay, all right. Well, I am going to admit the document that,
Yes, ma'am.
but your objection will be on the record.
and this, you said it's the trial transcript.
Yes, those two big ones.
Is there a reason why it's out of order like that? Or?
So that's the first volume, so it's R3A, and this is R3B. These clamps only hold so many papers. So
And again, it would be no reason for you to take out patient with you.
Thanks for making this copy for me.
that one is the motion for the trial transcript, I believe.
I would like to put on the record, this is the icing on the cake.
All right, that's R5, R4, sorry.
No, this one, yeah, this is.
All right, so do you have any objection to, I guess we got R1 and R2 in there, is that right, Patty? So we've got R3A and 3B, that was the trial transcript. Any objection to that?
Just as, the scope, what would be the scope of the, what what is the document used for as far as review? Are you reviewing the nature of what was said in totality, or just specific page numbers?
Specific to your petition.
Okay, and those page numbers, have they been established, or?
Well, I mean, what we typically do is we'll take and look at all of it, and just kind of specific to what grounds you raised, that's what my order would be based on.
Okay, so the review, that's what I'm basically trying to get on the record, the review of those documents, is it the totality, are you gonna look one by one, each page, each document, or is it, you know, you go through the document and you find specific, phases of the trial and then review it from there? How do you normally review the document? You go page by page?
I normally just look at them and then look at what you've raised and then kind of compare what you raised to what I've raised,
Okay.
and then go back to whatever I need to review again.
And I certainly would have no objection if Mr. Elam wants to, after this hearing, write into the court, you can write a brief and like say these are the specific page numbers and like.
Oh, well, I would, if that's something you want me to do, I can most definitely do that. I would just want the court to view it in the camera, and just total the entire, because the appearance of the property is so strong in the record.
Okay.
I would want to.
So you want me to consider all of the whole?
Yes, ma'am.
I understand that.
I understand that's a lot to ask. I wouldn't want to do it,
No,
but,
it's fine.
yeah, just what I know about Honorable Bryant, you know, good at what you do. To review the record and totality.
I'll do that. Yes, but I'll find the documents and then we documents are the same, quickly as I can.
So it depends on the review, order, or do you work it?
I don't know if it's proper. Are you going to try again, or?
Oh, come up, run it for Doug. Yeah, I've been doing it for 3 years, so
Here?
hopefully, you know, it's all that, you know, that's the kind of things that I always have to take into consideration, so, yeah. Is the battery still on the microphone?
I'll be.
How about that?
I thought we had 2 more. That's almost too bad.
But they go out in Christian and the courthouse, they make this all.
I think he had to go somewhere.
couldn't do it. I just couldn't handle it. I couldn't watch him fight like that. It was just tearing me to pieces. How bad was it?
It wasn't bad.
What did she say?
Well, she took all that's her right there.
Yeah.
She took all the documents. She's gonna overlook her, make her ruling. She gave him opportunity to respond to the late response from this lady that had all of the...
You're not gonna see him. They pull around that gate and get him at that door back there. They don't bring him out here to this parking lot.
Okay, so what are we doing?
We're gonna go to that, hotel that, I'm trying to give